What the defense will do is zoom in on something, and what we're doing is pulling back so you can see the full picture. You didn't pull a rabbit out of your hat, you provided context. Things need to be in context. If they're out of context, you can reach wrong conclusions. If you move onto their playing field, you've lost. And so now you're not playing on their field. You're pointing out how their field's rigged.
We're here for Season 3, Episode 4 of The Art of Outsmarting with Keith Mitnik. I'm Will Lewis. Today we're going to talk about providing context to show the flaws in the defense argument, and in particular, how you can do that during opening statement and early on in the case to get ahead of the defense's positions. So Keith, today we're talking about the next strategy, the next tool in your toolbox for providing context to set the record straight. And I know that this is something that you do throughout the trial. In our last episode, we talked about how we use education for cross-examining defense experts. Can you talk a little bit about how you use providing context in relation to cross-examining defense experts?
Great question. It is, they're very similar. To me, I see a bright line distinction, but if I just started talking and didn't point out why, there's a lot of overlap, because you're educating the people and you're providing context to the people, all so right conclusions get reached as opposed to wrong conclusions. What's the difference? In my mind, the difference is educating is teaching them something that's typically more scientific or math, the engineering side of it, the medical side of it, or in voir dire, you're teaching or educating about how bias works. It's really taking something someone doesn't know anything about and informing them so they can see the fatal flaws with their own eyes. Context, to me, has more to do with, people use the phrase cherry picking. I don't like cherry picking because it implies you're picking the good stuff. Why don't we pick the good stuff and not waste the jury with all the irrelevant stuff? So I like to call it cut and paste. I like to call it zooming in, extreme zoom. I use in closing arguments sometimes an analogy about, you can use here in Florida, or if you're in New York City, you can let's use the rowboat pond in New York City. I can go to the rowboat pond in New York City in Central Park, zoom in on one of those turtles on a rock with a log and a tree in the water, and you say, oh, you're out in the countryside. And then you pull back and look at the big picture, and you see the skyscraper, say nothing could be further from the truth. We're in Central Park in one of the biggest cities in the world, New York City. So what the defense will do is zoom in on something, and what we're doing is pulling back so you can see the full picture. So that's the zoom in. The other is, I'll say, cut and paste sometimes. But the point is, when we're talking about context, typically, as opposed to teaching about something scientific or that the jury doesn't know, we're giving them the rest of the story. The defense loves to say, any of you old enough for Paul Harvey, and get them to say, now the rest of the story. I always hate that one. It's so hokey. But the concept is the same thing. We're going to provide all the evidence so the jury can see what the right conclusion is, as opposed to something in a vacuum. By the way, that's a phrase I use all the time. You cannot assess evidence in a vacuum. It has to be looked at in context.
And can you give us an example of how, a situation where you would talk about or address a defense expert in specifically concerning putting something they say into context?
Sure. I'll give you a perfect example. In our last one, we spent a little time talking about these biomechanical experts, especially the biomechanical MD experts. Here's a context. It's not really as much education. This really fits more on the in context versus out of context. And that is, they will use the activities of daily living, and they'll say, that's like stepping off a curb. And I thought, well, wait a minute. Stepping off a curb isn't going to hurt you. They're right. And they're technically probably right that the G-force is, I'm not technically probably right. I'm sure the G-force, whatever they're saying, of say it's 2 or 3 or whatever it is, a stepping over a curb, I'm sure that's accurate. I don't agree at their eyeballing to look at the picture of some other crash to say that is the G-force. But that's a whole different subject. But there is a distinction in context of stepping off a curb. It's the distinction is this. Was it planned or was it an ambush? I can step off a curb probably 100 times in a row. I will hurt nothing. Other than at my age, I'll probably have a sore hamstring or something. But I'm not going to get hurt. Why? I know it's coming. I'm prepared for it. We have a gentle landing. I scripted it in my head, and I executed it. It was planned. Now I can step off that exact curb. I just did it 100 times, wasn't hurt, and proved their point. Now I'm turning around talking to somebody, not paying attention. I take a step off the curb awkwardly and unexpectedly. I'm ambushed.
You know, I think that's something we all can relate to as well, because who hasn't stepped somewhere where they didn't see it coming? And it doesn't have to be you fell into a well to get hurt. If it's sometimes it's just a little gap in, you know, a little depression, and you're like, wow, in my lower back. It
I
catches
just did
you
it
off
on
guard.
my stairs at my beach house. I was going up, had on my flip-flops. It's not one of those that goes up in your toe. It's the band across the damn top. And for whatever reason, my fat foot, I swung it around and it came off a little bit. And I was grabbing it as I was walking with my toes so it didn't go flying. And I stepped a little awkward. Just stepped a little awkward. My wife said, "You're all right." She heard me kind of clump down with my foot. I didn't fall, nothing. I said, "I'm fine." And I didn't want to confess to her. I walked away and went, "Dadgummit, I had a stinger in my low back. Bother me today."
And that's not a 1 foot curb. That's just,
stepping awkward.
Yep.
So that's one of the things, just we're off track, but when people talk about not a lot of visible property damage, I say it's not about the bending of metal, it's about the unexpected awkward jarring that causes injury. It's the same concept. So that's given context. I'll give you one more with the biomechanical experts, and that is, remember we talked in the last episode about the used dummies and dead people for the tests. Occasionally they use the live person. The live person, they have them sign a consent form. Tells you all you need to know. I left something out because it really didn't fit education. This is really more in the context vein. Same thing. When every single one of those people who were subjected to those human tests, they not only signed a consent form, they obviously knew the crash was coming. Mm-hmm. They knew the impact was coming. And the way people brace and prepare, if you know something's coming, you brace for it. I went to Africa earlier this year, first trip since COVID, and we took a balloon ride over the Serengeti. By the way, if you ever get a chance to do it, unbelievable. But when we land, you know how they put them damn balloons down? They just bring the basket and slam it down the damn ground.
You didn't think that through before you did it, right? You think about going up, you weren't thinking about going down.
You got to sit down, lean back, and they bring it in and tip it here. And he says, you know, sometimes you hit a big one of these big hills, they're not ants, whatever the hell they got down there, and it bounces up, and we may bounce a few times. Thank God we didn't. But when we hit, it was like, bam! You know, I'm 65. I'm like, shit. And it hurt a little. But he got me in. He said, we're coming, sit like this, lean back, hold this, strap this. We had all this stuff. And I was braced. But I guarantee you, had I suddenly flipped over in a chair and had the same forces, totally unexpected, I'd have been air vac out of the damn Serengeti. It's a different animal. So those are examples of context with experts.
And now, you know, and obviously, I say this, you know, I know you write books, so it's not stealing, but I've stolen so much of your strategies in my own trials, and one of my absolute favorites is the way you talk about providing context during opening statement. Yeah. And, you know, to me, I may do different things in my trial, but that is one of the absolute fundamentals I never leave out. And can you talk a little about the importance of providing context during opening?
Sure. The context is, I'm going to stick with car crashes just because it's so common and it reaches more folks that may be listening. It applies to every kind of case, but let's stick with that. Your client doesn't go to the ER right away. Now, in a vacuum, it sounds like, well, you're claiming millions of dollars because you got this lifelong living in pain from the crash. You didn't even see a doctor for 2 weeks, 3 weeks, let's say a month. Didn't go to the emergency room, didn't go to a doctor for a month.
I feel a lot of folks are scared of facts like that.
They don't even want to go to trial. They settle it cheap. because it's not a winner. And I understand. There was a time I would have thought that. I don't anymore because I've done it so many times now. I know the context changes outcomes in this. This is a perfect example of how you are a difference maker when you learn to properly package the same facts. You can dictate the right conclusion. And now you tried a case they didn't offer you peanuts on and got a big verdict, and they probably don't want to test you next time because they know that you know how to put it. And all you did was, you didn't pull a rabbit out of your hat. You provided context. So let's talk about this, not going to the ER and not getting treatment for a while in human context. And I do this in opening. It's just like you're going to hear. And in some of this, if it's something you're really concerned is you need to get it out early, and you're concerned you're not going to be able to do an opening because it's too much sounding like you're arguing, then you can work it into voir dire with just an experience question is the greatest way to do it. Let me ask your experience with going to the ER. And you get the same point across because there you're allowed to just talk. But I typically do it in opening and again in closing if need be. But so here's what you're going to hear, folks. Going to the emergency room is very time consuming. Most people get to the emergency room, they're going to be there 4, 5, 6 hours. You know who else is there when they're there? They're not there alone. All them sick people. You're liable to come home with gosh knows what. It's expensive. And if somebody breaks their leg and a bone sticking out, blood spurting, that's the injury. And they saw no emergency room and no doctor for 3 months. And they said that happened in the crash 3 months ago. You'd probably go, what? Why? Because it's a medical emergency. You got to go to the emergency room. You need treatment. You got blood spurting out of your leg and a bone sticking out of the skin. It's an emergency. It's not an optional situation. Now flip it to someone was hit, and you're going to hear from the evidence, a herniation typically starts feeling the same way a sprain does. Achy, stiff, sore, but you feel like you're going to be okay. It's indistinguishable to start with a hernia, with a sprain strain. So the person gets hit and they go, oh, I'm stiff, I'm aching. A whole lot of people, including my client, aren't going to race to the emergency room because they're not having a heart attack, they're not bleeding, they didn't get a gunshot wound. It's not a medical emergency. They have choices. And they got ice cream in the back's going to melt. They got kids to pick up from soccer practice. They got a hearing, they got to go see a judge. Life goes on. And they don't want to spend 4, 5, 6 hours at the emergency room and a bunch of money and a bunch of sick people when they think they're okay. So they don't go to the emergency room because they're counting on them, I'll feel better tomorrow morning. They wake up tomorrow morning and they don't feel better. That's what happened to my client. Did they go, now I got to call the ambulance? No, because they're aching and sore. They're thinking, well, it's going to be here for a few days. Now you're getting out 6, 7 days. Wife says, why are you rubbing your neck? I'm still sore. It's not getting any better. Maybe you ought to go to the doctor. Let's give it a little more time. Get out 2 weeks. Still not better. Honey, you need to go to, all right. Call the doctor. I will. Calls the doctor. Says, all right. They don't call and say, medical emergency. At the beginning of the tape, it says medical emergency, hang up and call the ambulance. It's not one of those calls. So what do they say? Well, the next time is next week, Tuesday at 10 o'clock in the morning. I can't do 10 o'clock in the morning. I got something I got to do. Okay, well, how about the following week on Monday, we could do 9? I'll take it. Guess what? It's now a month. Does that mean they weren't hurt? Because they didn't go to the emergency room and they waited to go to the doctor. Does that mean they aren't hurt? Or does it mean they're not a big baby? You hear that? Who's going to say you're not hurt? Who's not going to go, yeah, I understand that. All we just did is provide context to something that sounds suspicious. There's nothing suspicious about, same thing, gap in treatment. I hear all the time, gap. I tried a case with someone, I won't say who it is. I tried a case with someone this last year. And I said, anything I need to worry about? Da, da, da. I said, any gaps? Now, this is someone who was new to civil. So in fairness, didn't know what was going to be used. Afterwards said, God, I see what you were asking. I didn't really understand when you said gaps. And that was on me. I should have been clear. But any gaps? No, nothing to speak of. Okay. Get in trial. There was a 2-year gap in treatment. No treatment for 2 years. I'm like, I said, I heard it in opening. Didn't deal with it. You know how I got to deal with it. I'm like, oh. I said, if that's not a gap, what the hell is? It's only been 3 years since the crash. We got 2 with no treatment. But guess what? We got a big 7-figure verdict, even though I didn't do an opening, which is, I don't recommend that. But context. So what's the context with a gap? There is a fundamental flaw with a gap in treatment defense. And all you got to do is tell the jury about it. You can do this one in voir dire. The whole premise is no doctor equals no pain. No doctor equals no pain. If it was that simple, who in the world would ever, who's in pain, go see a doctor? They could cure themselves, just quit going. And that's ridiculous. So why did they go in the first place? They were looking for a cure, hope for a cure. Every time you go to a doctor, it's a black hole of time. It's a half a day. Time you drive there, wait to get in, see them, get out, check out, and then drive back home. It's a half a day. Who does that? Hope for a cure is why. What happens when there is no cure? You're going to live with it the rest of your life. You're going to live in pain the rest. We can bring it down for short periods of time, a little, but people get on with the business of life. That's not a gap in treatment. That's recognizing hope for a cure is gone. I got to live with it. I can't live at the doctor's office just to get a little temporary relief. I'm too busy.
Now, and I don't mean to interrupt you, but I know there's probably a number of these you see often. Gaps in treatment, not going to the ER, priors that you try to get out in front of. How do you? And I think it's a challenge for many of us. Giving an opening statement. How do you balance providing context, getting out in front of these issues in opening statement, without making opening statement all about their case? So, I know you probably saw this question coming, and not about your case.
You can't try their case. If you move onto their playing field, you've lost. You can't skip the stuff that you could lose over because the juror's going to say, I thought you had a good case, and look down at you and say, when were you going to tell me about that? And you lose because you have an answer, you didn't give it. And you know what else they think? If you had an answer, you would have given it. So what do? You draw this line. I asked myself, not every little point they're going to make. What are the points that could make me lose? If I skip this, what are the ones when I'm home tonight and can't sleep, I'm going to be kicking myself for giving it a free shot? Because that one could be the difference between winning and losing.
In your run-of-the-mill case, 3, 4, 5 points, is that what you would say? Or
yeah, you start getting past 5, you're really. But here's some good news to expand that. A bunch of them can be built in to the front end, meaning built into your positive side of your case. I'll give you an example. Very good lawyer in our firm was doing nursing home, and I tried cases with him for 25 years, so he knows my stuff. And he came to me all proud of what he was going to do in an upcoming trial. I wasn't going with him. It was a bed sore case. It involved someone who had diabetes, and they were very susceptible to getting a bed sore. And if they got it, it makes it extraordinarily hard to get rid of it. So the defense was, you got bad diabetes, what are we supposed to do? This lawyer, who did everything right with one exception, that's going to make this point. He said, hey, Mitnik, I want to tell you what I'm going to do with this. And he tells me what I just said to you. I'm going to tell him all about my client's case, then I'm going to say, and the defense is diabetes. And I'm going to say, but, and then gave the perfect answer after but, which is, they knew before he ever came in he had diabetes. So they knew he was at greater risk. And they still didn't turn him, knowing that he was at risk to get it, higher than usual, and it'd be very, very hard to get rid of it. And they didn't do their job even though they were on notice of it. And they agreed to take him in for a fee knowing he had diabetes. And I said, brilliant. I said, accept. And I saw the lawyer's shoulders like, is there always got to be an accept?
Been there. I can relate.
And I said, brilliant, but don't say but. The minute you said, they're going to say this, but, everything you say after but is here come a bunch of excuses. What if instead of but you said, and to make matters worse, they knew, took them in, charged for it, said we got your back. And then now they're saying, it's a do-it-yourself job. We didn't have your back. We didn't mean it. And then, by the way, they never offered a refund. I'm going to sit down because I want to hear how they're going to explain the fact he had diabetes and they knew it and they accepted him as a patient and promised to care for him, knowing if they'd let it happen, it was never going away probably, and that it was at high risk for it happening. How in the world they didn't turn him? I want to hear their explanation. Now, guess what? You can take that off your list of 5 that you had to deal with it then, because now it's one of your favorite facts. You just moved it onto your side. If it's a tennis match, it's on. You're serving now. You're not having to return the heater. You're serving the heater. So a whole lot of these, whether it be education, whether it be context, whether it be creating language of your case, whether it be creating the pictures, every time you can take one of those conclusions that they were going to try and reach that were wrong by twisting the facts and move it over into something you're proud of, it's less to deal with. And the ones that don't fit, because everything doesn't, you at the tail end say, I'm about to sit down. I have a good idea what they're going to say. We don't have a lot of surprises in modern lit lawsuits. And I want to talk to you about what the evidence is going to show, because we all know things need to be in context. If they're out of context, you can reach wrong conclusions. And it's important that things not be looked at in vacuum, but in context. So before I sit down, I want to bring up a few things they're going to talk about so I can give you proper context. Then you go into it. Now, you are doing it in a way without saying it, because you don't want to be over-argumentative in opening. What you're basically communicating is they were about to pull a fast one, and I'm stopping it. And so now you're not playing on their field. You're pointing out how their field's rigged.
And try to narrow those issues as
And
much as possible.
don't go on for 20 damn minutes about it. It better be surgical, in and out. And spend time thinking about how can I say that quicker and shorter. There are times I do it longer. If you're in the side that you're really giving them context, you can't own it, surgical, boom, boom. How fast can I make the point and get it? You don't have to explain it till the cows come home. That's one of my faults. I'm an explainer, and I'll go too damn long and then I'm mad at myself. Figure out in advance, how can I say it quick, surgical, in it, out. All you needed to do with that is neutralize it. You just don't want them to look down at you and say, why didn't you tell me about that? Give them a free shot.
Now, I'm going to keep picking your brain here, because there's just certain issues that come up in cases over and over, and that we have to face and deal with. How about liens?
Yeah, that's a big one. Years ago, not even years ago, a couple years ago, 3 years ago, I didn't think they did very good with liens. And I had some things that I would do, I think just neutralize them. I just didn't worry about them. They'd gotten better at making it look like some big conspiracy.
Yeah, with everybody coming together.
They're all coming together, and they all got a stake in the outcome, and no wonder they're saying all this stuff. And especially with a biased jury, it can sink in. And even with a non-biased jury, if you're not careful, it can score. So I've revamped my lien stuff. There are a couple things. And this is pure context. I'm glad you brought liens up, because it couldn't fit any better. What's the fact? Your doctor signed a lien. There is a lien signed, your client.
There's a document, it's right there, it's in black and white.
It says black and white, you owe the doctor from the proceeds of the lawsuit, which sounds like you got a stake in the outcome. So what's the context? Okay, let's give some context. Every doctor that walks in this room or is on a video or Zooms in, every one of them, all of them are on some kind of payment plan. They're all getting paid one way or the other. None of them are giving their time away from their patients, not getting paid. And that's a factor you can factor in. Just factor it in evenly to everybody. But the issue isn't because they're all getting paid. One format or another, they're all getting paid. The issue isn't payment. The issue is, what's their role? What's their role? And these treating doctors all have a patient. That's their role. They got a patient. They end up a witness, but they got a patient. The hired expert by the defense, he's got a customer. He didn't have a patient. He didn't have to worry about giving a wrong diagnosis because he didn't have a patient he's responsible for. He can say whatever he wants. The problem is, he's basically telling you what the diagnosis is that's going to impact future care. So he might as well be giving it. He just has no responsibility. Why? Because he's got a customer. He doesn't have a patient. That's the difference. And when you explain that, and here's another context. If it fits, doesn't fit every time you have a treating doctor who's on a letter of protection. But there are two things that will change that entirely. One, don't tell them there's a lien. Ask them. When you're prepping them, do you know whether or not it's a lien? If they say no, stop. They goes, well, I can check. Tell them, don't bother. You don't need to. Now you put them on the stand. Do you know if there's a lien or not? I do not. If they don't know it's there, how could it have influenced their testimony?
Many times they're not, the doctor isn't the one where the lien's going anyhow.
It's a business.
They've been paid up front.
Yeah. And then you say, have you been paid? If they find out first, oh, yeah, I'm independent. I've been paid.
Yeah.
Well, how could it impact them? I mean, you could string shit together to make the point, but it's a stretch. Here's another one. Let's say they do know about it, and it is their practice, and they've done a bunch with your law firm. If this is true, and usually it is, yeah, but do you have plenty of patients? Oh, yeah. Do you need to take cases on a lien? No. So why do you? Well, first of all, if you can say, health insurance can be a hassle. I don't have that here. But if that can't be said because of the law, then if they can say this honestly, it's powerful. I don't take every case on a lien that comes to me. I make a preliminary decision. I meet the person, see, do they seem legit or do they seem like some big faker? And I look at the basic circumstances. I don't have all the evidence, but enough where I can tell. This sure looks to me, common sense tells me this is related. Medicine tells me this is related. It's not all just a big coincidence. And so if it looks related and they look like they're legitimately hurt, I'm okay waiting. That's fine with me. But if I thought it looked unrelated, I wouldn't touch it. Why would I do that? I'd end up working like, God, I could be on this thing for 2 or 3 years with no real chance of getting paid, because if it ain't related, I would expect the jury to say it isn't related. So now the treater's turned into basically an expert on credibility.
And it's the truth.
And it's the truth.
That's the thing is that it's something that maybe, we might not think to bring up, but it's the truth and it supports our case. And we should probably bring it up more. All right, one last one. I'm throwing you all the challenges, all the hurdles here, but I love these, these little, strategies and bits of knowledge. Surveillance. Well, you and I obviously we tried a case earlier this year where our 20-year-old client had TikTok post crash, had TikTok videos that were showed a lot of athleticism, and played a year of collegiate soccer.
And guess who filmed it all?
Filmed by the defense after the crash, and it was obviously a hurdle. But that's the worst part is that she was hurt, and I thought you did a really great job of bringing out the truth despite that surveillance. Can you talk a little about how you did that analysis and how you came to that strategy?
Yes, that was one. When I saw it, you go, well, this is worse than some. No aha, no, oh, gotcha, you lied about it. There's absolutely nothing she said that she couldn't do that was on the. But I mean, she's out hitting with headers and racing down the field and guarding and shoulder checking and whatever. I'm not a soccer guy, but whatever they do. Fit as a fiddle, and the TikTok videos I'm watching, all this jerky. I'm thinking I'd be in the hospital if I did that stuff. And so, what do you do with it? you tell them an opening. It's just pure context. Now this, we couldn't know. This was a classic in context versus out. You're going to see this video of her playing. Here's what you're going to hear. Is she's never said this is it, that she can't play soccer. Ever. To anybody. Because she could. Think it's some big secret she's out there in the middle of a lawsuit, someone might be watching her. She got nothing to hide. But here's what the evidence is going to show. She went from a starter who was the star, who was a freshman. They gave her a full scholarship at this small school. And the small school usually split the scholarships up because they didn't have enough for all their players. And they gave it all to her. She was that good her first year. And you know what they aren't going to tell you is every bit of that footage they show that looks like a lot because it's a whole season. It's her at the end of the game coming in off the bench because she just can't play like she did before. And you know what else? She's tough as nails and she ain't a quitter. She doesn't, she bucks up. She doesn't give up. This is a dream. She was wanting to get a major college scholarship after the small 2-year scholarship. He was on track, hopefully, to get one. And now she doesn't play the thing she worked so hard her whole life to get that good at all. Not because she can't play it like she expects of herself to play it, because she ends up laying on a heating pad. You know what they don't do? They don't follow her home and watch her lay on the heating pad. She didn't even own one before. So, and she dances. She's young. She can dance. She's never told anyone she can't dance. It's pretty impressive dancing, and it's jerking around. But you know what? She's 20 years old. All her friends are doing the take. She's going to sit out and say, I can't? And what would people say if she said, because she can do it, if she just didn't do it? Quitter? Putting on? So they're going to hold that against her after they did this to her for her whole life? And guess what, folks? People get used to pain. When people live in pain, they get used to it. They react to it different. When you first have pain, it's, oh my God, my neck's hurting. You got pain for the last 3 years, you wake up, good morning, it's like the sunshine. You know it's coming. They get used to it. You know what else? People that are flinch on the camera because they're having some pain, I'm not talking about hitting your finger with a hammer. I'm talking about now chronic, live with pain. People don't flinch to that, and if they do, they're either softies, babies, or they're putting on. I'll give you a quick example of the same kind of thing that I did to someone up in Gainesville on a big verdict we got. And they had a guy who used to be an Orlando Magic doctor came in, very aggressive jackass, and as an orthopedic. And he was in getting his credentials about working magic. And our guys, we had 2 clients consolidated. And they had surveillance out with these big pole saws, sawing limbs up over their heads, and using this big damn blower, blowing stuff with a backpack blower. I ain't talking about a little hand blower, big old backpack. And, just tons of footage of it. And I got the guy up and cross. And I said, I heard you say on direct examination about how you work with magic. I did. I said, those guys, they live with pain, don't they? Oh, yes. Some of them have some pretty serious sprained ankles, all taped up, and they got shoulders this and that, and fingers, everything hurting. Yep. I said, and I watch them play. I used to go to the games. I said, they don't run up and down going, oh, do they? They look like ballerinas and gazelles, don't they? Yeah, what's your point? I said, if you don't get it, we don't need to talk anymore about it.
And you kind of made the same point in the case back in March was they don't have video of her after the game, icing herself down, all these things that a 20-year-old shouldn't have to do. And I thought that was powerful as well. One last thing on surveillance, because I know it's one of those topics that everybody's keyed into. What are your thoughts on when to play the surveillance?
Sure. With your client, let them edit it. You don't want them playing it and your client never faced it. They got to face the music. This ain't a criminal case where you say, they got a right not to testify. You better confront it. It's a civil case. Play it. So I tell them an opening. There's not one thing on here, nothing It's inconsistent with what my client says. In fact, we're going to play it for you. It confirms everything she said, and then gives some of this context we just went through. And then I do it through them. But you got to ask this in voir dire. Let's wrap up with this. This is a essential part of the surveillance. How many of you feel? First, you explain. Everyone's heard of surveillance. And by the way, a lot of people want to try to make the defense look dirty for following them around. I've never seen a jury react that way, so I don't even do it. I give it to them. I say, someone's in a lawsuit and suing. Sometimes they follow them around secretly. They don't let me even follow. It's called surveillance. Y'all have heard of it, right? Nothing wrong with it. Someone's suing them. They got a right to follow them around. See if they're doing something they say they couldn't. And we've all heard of extreme examples where like someone got millions of dollars and then were out doing a jig after they got the money by the big sailboat they bought. I usually get up and do a little jig. I say, it makes you sick. Anybody who cares at all about justice, it makes you sick. That, by the way, we just pop the blister, squeeze the pus, and they know it ain't us with the blister I wouldn't be talking about. I say, but there's another kind of surveillance. The one that absolutely doesn't show anything inconsistent. It's consistent with what they say. Some people feel that even with that kind, if the defense went to the time, trouble, and expense to get it, there must be some faking or exaggerating going on, or they wouldn't have done that. Maybe they didn't catch them. So how many of you feel if the defense went to the time, trouble, and expense to get surveillance, regardless of what it shows, you would start out believing there must be some faking or exaggerating, or they wouldn't be wasting their time, money, and expense? I get people for calls all the time. And the rest of them, I come back and say, so you'll make no assumptions by the fact, just the mere fact they did it. Nope. Wait and see what it shows, and shows if it shows any inconsistencies. Yep. Then opening, we're going to be showing it. Because remember, we talked about it in jury selection. Zero. It's absolutely consistent.
So by the time the defense talks about it, you've already talked about it twice.
And then they want to go back and replay it in their case. Play it. Turn the lights down. But you don't want the first time turn the lights down and all the drama and do it. Now people are sick of it. They're ready to get home. They usually do it right before closing arguments. The jury's like, do we have to watch this again?
That's great. That's great. Well, look, we covered a lot of the challenges that, we face as plaintiffs, lawyers, and trials today. Lien, surveillance, biomex, some of the big ones. That was really valuable. So thank you for your time today, Keith.
Yeah, this is important stuff. Thank you.
During this episode, we dealt with a number of the key issues that we as plaintiffs' lawyers face in injury trials: surveillance, liens, matters like that. And, from trying cases with Keith, I cannot tell you how much emphasis he puts on providing context to those issues, getting out ahead of them, not starting in a hole. And that was truly a very valuable episode and a lot of good practical tips. And in our next episode, we are going to finish off the providing context toolbox with talking about how we provide context in closing argument and how we come full circle, and again, making sure that the defense flaws are exposed so that the truth in our case can become clear to the jury.
We have now nailed down the time and the place for the next Art of Outsmarting event. We're going to be in Orlando. We're going to be at a fantastic venue called the Dr. Phillips Center for Performing Arts. It's a new facility. We did it there last year. It was off the charts good. I promise new materials, and I promise a brand new format I've never done before that I'm so excited about. I can't wait for May to come. See y'all there.